So guys, Nnamdi Kanu's 5 defense points and evidence is already ready ahead of tomorrow. Nnamdi Kanu told his counsel, look, step down, I'll take over this defense. And his reason was that there are some names his lawyers might be afraid to mention, that he wants to take over the defense himself. And 5 evidences are already ready, which I'm going to be showing you in this very video session. But before then, Nnamdi Kanu's lawyer, one of Nnamdi Kanu's previous lawyer, Maxwell Opara, who was in charge of this very case, he came up and gave a brief report concerning the arrest of Aloy Ejimakor, Sowore, and Fineboy, which is Nnamdi Kanu's junior brother. I want to display this very report here briefly before heading into the 5 strong evidences Nnamdi Kanu is ready to battle with tomorrow in court. Because Nnamdi Kanu has said, look, I will defend myself. And for Nnamdi Kanu to come out and say, I will defend myself, it shows you the level of courage and intelligence Nnamdi Kanu has. And Nnamdi Kanu is already ready. And it's already determined that he's going to defeat Tinubu and Omoyele in court tomorrow. Well, I'm going to be showing you those 5 evidence. But before then, Nnamdi Kanu's junior brother was arrested in the previous protest, and Aloy Ejimakor. And Maxwell Opara has an update for us. Just tape it and listen to what he had to say. And after listening to what Maxwell Opara had to say about the current update, we are going to be heading straight to the 5 points Nnamdi Kanu will be using in court tomorrow.
It's just an update. I came up from DSSS where I went to see Nnamdi Kanu, and I received a series of messages that Aloy Ejimakor collapsed at a Kuje Correctional Center where he was remanded. So I rushed to the Kuje Correctional Center and I demanded to see him. So the officer in charge directed that the officer should accompany me to the clinic where he was admitted. So I met him and we discussed, and I asked him, so he told me how everything happened. So, such a man of over 70 years, you tear gassed him, you treated him like a criminal, you subject him to such ill treatment. So, we don't expect his body chemistry to be the same. So, and it's very unfortunate because this is what we call executive recklessness that leads to this. And they use judiciary to perfect the illegality. Because had it been that the magistrate, having known that this is an act of intimidation, this is an act of lawlessness, you shouldn't have even, you should just release such a man on self-recognition. On self-recognition. We have seen where people committed very big crime in this country. They release them on self-recognition. Not talk about a very senior lawyer. A man of over 70 years. It's rather unfortunate. So he met up with the bail condition given to him by the court and the other protesters. So, and they perfected it. So it's for the judge to sign for order for release. That was around 11 yesterday, Friday, 24th. Waited for the judge from 11 in the morning till around 6 p.m. when we left from the court. The judge was nowhere to be found. People were, the registrar, everybody were waiting for him. So I don't know what they want to achieve. It's unfortunate. So I saw him there, just like I said. I saw Omoyele Sowore, I saw Prince Kanu, I saw Tinubu and some other protesters. So and I believe, so by Monday they will be out. Thank you. That is the update.
So guys, let's get straight into business. Key defense points Nnamdi Kanu will be using tomorrow in court against the federal government of Nigeria and Bola and Tinubu. Number 1, no direct evidence of incitement to violence. And I read, the defense argues that although Kanu made broadcasts and statements, the prosecution has not produced a witness who says they were directly incited by him to commit violence. Don't also forget that during the proceeding, the DSS operatives brought in a masked witness to come and testify against Nnamdi Kanu. But when he was asked by Justice Motosho, did Nnamdi Kanu send you directly to go and incite violence? He denied it. And this is one of the points Nnamdi Kanu will be using in his defense tomorrow. Let's continue. They claim that some of his statements may amount to strong rhetoric or political speech, but they should not automatically be deemed terrorism unless the requisite legal elements are proven. Nnamdi Kanu is saying that his speech shouldn't be used as a statement against him or as a weapon against him, because those statements, he had a right, or he had the necessary right to make any statement or any broadcast from anywhere, but at no point did he incite violence or send anyone to commit violence in any part of the world. And this is one of the arguments Nnamdi Kanu will be raising up in court tomorrow. 2. Questionable evidence, in brackets, authenticity, form, and scope. The defense questions the reliability of audio/video recordings used by the prosecution. Example, whether they were properly authenticated, unedited, and admissible. They contend that the prosecution amended the charges many times, in brackets, 8 times in one case, which they argue introduces issues of fairness and notice. Nnamdi Kanu is saying a charge was amended 8 times. This is against the law. This is a point that Nnamdi Kanu will be raising in court, because how can you amend a charge over 8 times? This Nnamdi Kanu is saying that this is against the law and it shouldn't be used against him, because this is an evidence he has in court. Because to show you that Nnamdi Kanu had no case to answer, they kept on amending the charge and amending the charge and amending the charge. Even when the appeal court 2022 vindicated Nnamdi Kanu, saying that Nnamdi Kanu had no case to answer, they kept on amending those charges. Let's head to 3. Burden of proof / presumption of innocence. A foundational point. The prosecution must prove every element of each charge beyond reasonable doubt, and Kanu is presumed innocent until proven guilty. The defense emphasizes that until they see evidence of direct linkage to violent acts, mere speech or advocacy alone should not suffice for terrorism convictions. Nnamdi Kanu is saying that if a direct evidence, a direct person that said, look, I sent you to commit such, is not provided in court, that whatsoever they are doing is dead on arrival, and it shouldn't be used against him for terrorism convictions. Because those people that DSS witnesses brought to come and testify wrongly against Nnamdi Kanu, to show you how evil and how wicked these people are, they quickly leveled those witnesses and placed a terrorism conviction on Nnamdi Kanu. And this is Nnamdi Kanu saying that, look, no direct linkage has been made directly to me, that whatsoever you guys are doing are all fake and trash. Let's head to 4. Political and advocacy nature of his actions. The defense will argue that Kanu's broadcasts and activism, in brackets, via indigenous people of Biafra, had a political dimension, an agenda of self-determination or redress of grievances, which is fundamentally different from terrorism aimed purely at mass violence. They argue that other public figures have made strong statements about self-defense or resistance, and Kanu's statements shouldn't be placed in that context. Now, Nnamdi Kanu, there was a time Nnamdi Kanu said that he's going to defend his people. This is Nnamdi Kanu saying, is self-defense now a crime? That other well-meaning Nigerians and other popular Nigerians and other politicians have emphasized on self-defense. That why does his statement shows that he committed a crime? That he is innocent, that he has no case to answer. Everyone has a right to self-defense, and this is what Nnamdi Kanu is stressing in this number 4. Then finally, 5. Procedural / jurisdictional / rights-based issues. The defense raises questions about Kanu's arrests. extradition in brackets or rendition from Kenya, and whether that impairs the court jurisdiction or affects his rights. Although, in one ruling, the courts found no evidence on record for the extraordinary rendition arguments. They argue about his conditions of detention, access to legal counsel, adequate time to prepare his defense, pointing to possible fairness/rehearing issues. Why these points? These points attempt to undermine the prosecution's case by showing gaps in proofs, in brackets, evidence, linkage, caution. Now, ever since I've been bringing this charge against Nnamdi Kanu or upon Nnamdi Kanu, they have failed to show or prove a direct evidence, which clearly shows you that Nnamdi Kanu has no case to answer. Let's wrap it up. They seek to shift attention from what he said to what effect it had, in brackets, or didn't have, and whether that effect constitutes terrorism under Nigerian law. Nnamdi Kanu made statements. He made statements of self-defense, in brackets. He never incited violence anyway. And Nnamdi Kanu will surely defeat them in court with these very points, because these points are clear, even to the blind, that Nnamdi Kanu is innocent. And up until this very moment, to tell you, they haven't been able to prove Nnamdi Kanu guilty. This is 4 years of trying Nnamdi Kanu. They have not been able to prove Nnamdi Kanu guilty of any crime, which shows you that the injustice against Nnamdi Kanu is getting out of hand. At this point, I'll let you guys tell me what you feel about this in the comment section below. We pray Nnamdi Kanu defeats them in court tomorrow with this point he has. Like this video, share this video, and hit the subscribe button below for more trending updates.